The truth is, you're as dumb as they come.
We have one person here. Let's see if we can get more. That's crazy. How's that even possible? All right. Well, somebody type something in. Jesus. Hey, Missy Six. How's it going? Yeah, they just had a hearing earlier today. And Tyler Robinson, the contempt hearing in the Tyler Robinson case. And, you know, it's pretty interesting because the judge ruled in contempt on like half of it. You know, he didn't rule contempt on correcting the information regarding the ballistics. I think the defense should have been brought up on contempt for purposely putting in false information in a document they knew would be seen by the public out there. All right, and that's what led to the misinformation that the media was putting out, and then the prosecutor corrected that. But then the judge says where he went overboard was when he said that we believe he did this and we'll have the evidence to do that, but he's innocent until proven guilty. I don't think there's anything wrong with that at all. It's literally saying the obvious that everybody knows. So anyways, what we're going to do is we're going to play the hearing right now, okay? And the remedy is not, they didn't take away the death penalty or anything like that. It's just about going to be jury selection or something. But it's interesting to listen to it, how they, you know, how he came up with it. I mean, he's worse at reading than I am, though. This guy is like... I mean, I don't know what the deal is with him. But I totally disagree that it was contempt to state the obvious. Of course, they think that they have the information that'll find him guilty because they wouldn't be putting a case on if they didn't believe that.
Impartial jury trial.
Right, so here we go.
Tyler James Robinson, who was charged with the aggravated murder of Charlie Kirk, a conservative activist, which allegedly occurred at Utah Valley University. Because this case has garnered immense national and international media attention, this court recognized early in the proceedings.
And there was three other people in there. I'm just putting the two sort of main people below and then the judge bigger. There was like other faces on there, you know, but.
That pretrial publicity could severely compromise the defendant's right to due process in a fair and impartial jury trial. To protect the fundamental constitutional rights of both defendant and the state, this court, sua sponte, issued a protection order pre-trial and trial publicity.
Well, thanks, Missy Six, for saying that. I mean, I don't know. Some people always say, Gray, you can't read, blah, 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 blah. Yeah, I think I do pretty good sometimes, but, you know, other nights, maybe not so much.
On September 16, 2025, the order explicitly stated that lawyers who have participated, who are now participating, or who will yet participate in the investigation or litigation of this case in any way shall abide strictly by Rule 3.6 of the Utah Rules of Professional Conduct. The order further incorporated Rule 3.6a's prohibition against making an extrajudicial statement that the lawyer knows or should reasonably know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Following a motion by the state for clarification regarding the term witness, the court issued an amended order on December 15, 2025, clarifying the scope of the attorney's duties to instruct their respective teams. The present controversy emerged following a public filing by the defense on March 27, 2026. The defendant filed a motion to vacate or continue the preliminary hearing.
Hey, what was funny about what Missy Six said there, Dragon? Somebody check out that account real quick. All right, thanks.
In that motion, defense counsel characterized a forensic summary report from the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, by stating that the ATF was unable to identify the bullet recovered at the autopsy to the rifle allegedly tied to Mr. Robinson. The actual ATF report concluded that the bullet jacket fragment could not be identified or excluded as having been fired from Exhibit 1 rifle, and that the results of the comparison was inconclusive. The defendant's framing of the ATF report in an unsealed public court filing promptly generated substantial media coverage. On March 30th, 2026, the Daily Mail published an article with the headline, "Bullet used to kill Charlie Kirk did not match rifle allegedly used by suspect Tyler Robinson," new court filing claims. Other news outlets and social media commentators rapidly echoed this narrative, characterizing the ATF report as exculpatory, a bombshell that exonerates Robinson, and evidence that the state's case possessed a fundamental problem. Faced with a rapidly expanding public narrative that falsely suggested that the ATF had affirmatively excluded the defendant's rifle as the murder weapon, Deputy Utah County Attorney Christopher Ballard engaged in several communications with media outlets.
Yeah, I mean, the thing is don't you guys remember that? I remember doing my show, doing the show right after, like, Daily Mail and all of them had these stupid headlines saying, "Oh my God, the bullet doesn't match," and everybody was running wild. These stupid Candace Owens fans were going, "Oh my God, they're going crazy," and that was, I believe, a purposeful attempt by the defense to put it into a document that they submitted, knowing that it was public record and could be read. I would actually submit that they are the ones in contempt. And so this, attorney went out there to set the record straight. Okay, and that part the judge allowed. So what you'll hear here is later on, the judge said that when the prosecutor, he went a bridge too far when he said, "And we believe that we have enough to overcome the burden of proof in this case," and sort of talked about that they think they'll find him guilty. I mean, isn't that obvious? Like, if they didn't think that, we wouldn't be having a case right now. So what is wrong with stating the obvious? All he was doing was correcting the record and making sort of a side comment that really means absolutely nothing. But the judge, with his wisdom, whatever the hell you want to call it, I think it's a blundering, foolish, it didn't create any damage, though, to the case. But it's just, I don't know, maybe he's trying to, protect something for the record in the future. Well, I did find him in contempt, but it wasn't egregious enough. Well, it's true, it wasn't egregious enough. In fact, it wasn't even close. It's ridiculous.
Including TMZ, USA Today, PolitiFact, and Fox News between March 31st and April 2nd.
And by the way, you guys, we're doing another show right now, so while we're watching, if you have the ability to help support the channel, that would be awesome. It would be great to not see zeros all the way across during this whole thing. That would be great.
2026. In these communications, Mr. Ballard sought to correct the record regarding the definition of an inconclusive ballistics test. However, during these interviews, Mr. Ballard also provided statements regarding the overall strength of the state's evidence, asserting that the prosecution had ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder, and that the state believed it would be able to overcome his presumption of innocence. On April 15, 2026, defendant filed the instant motion for an order to show cause for contempt of court, seeking to hold Utah County Attorney Jeffrey S. Gray and Deputy County Attorney Christopher Ballard in civil contempt. Defendant concurrently sought an order compelling discovery related to internal communications of the Utah County Attorney's Office, referred to as UCAO. The state filed its opposition on April 30th, 2026. arguing that Mr. Ballard's statements were protected under the safe harbor provision of URPC 3.6C, which permits a lawyer to make statements necessary to mitigate substantial undue prejudice generated by recent publicity not initiated by the lawyer. The state argued that the defendant's misleading public filing necessitated the response. Defendant filed a reply on May 7th, 2026. On June 1st, 2026, this court issued a ruling and order granting the motion for an order to show cause, determining that the defendant had made a sufficient preliminary showing under Utah Code 78B-6-301 sub 5 to warrant an evidentiary hearing. The court concurrently denied the defendant's request to compel discovery of the UCAO's internal communications. The court held an evidentiary show cause hearing on June 12, 2026. During the hearing, the court took testimony from Mr. Ballard and Mr. Gray, both who were subjected to direct and cross-examination. Following the hearing, the state filed an unsolicited objection to defendant's request to remove the death penalty as a sanction, to which the defendant filed a response on June 18, 2026. Having considered the pleadings, the exhibits, and the sworn testimony presented at the June 12, 2026 hearing, the court makes the following findings of fact by clear and convincing evidence. On September 16, 2025, this court issued a valid lawful protection order pre-trial and trial publicity. The order explicitly required all participating lawyers to abide strictly by Rule 3.6 of the Utah Rules of Professional Conduct and prohibited extrajudicial statements possessing a substantial likelihood of materially prejudicing the adjudicative proceedings. The order was subsequently clarified on December 15, 2025. Deputy County Attorney Christopher Ballard had actual notice of the publicity order. Mr. Ballard personally signed the state's November 6, 2025 motion to amend or clarify the court's pretrial and trial publicity order. During his testimony on June 12, 2026, Mr. Ballard acknowledged his familiarity with the order and his ethical obligations under URPC 3.6. At all times relevant to this inquiry, Mr. Ballard possessed unhindered ability to comply with the publicity order. There were no physical or legal impediments that prevented him from adhering to the court's directives. On March 27, 2020.
So really he's saying, hey, it was really crystal clear. You know, he signed it. He knew exactly what it meant. There was no impediments of any kind. He signed this order that I had.
Defense counsel filed a motion to continue, containing the assertion that the ATF was unable to identify the bullet recovered at the autopsy to the rifle allegedly tied to Mr. Robinson. The actual ATF report concluded the bullet jacket fragment could not be identified or excluded as having been fired from the subject rifle, rendering the result inconclusive. Relying upon the defense's filing, media outlets generated highly sensationalized and factually inaccurate headlines. The Daily Mail declared the bullet did.
Yeah, but the key is, for me, is the defense put highly inaccurate information in their filing so that it would be publicly noticed and then disseminated like that. I think that they should be brought up on contempt. Don't you? I mean, that's what makes more sense to me. That the originator of the false information to sway the public, guised as a typical court filing, I think that's even more nefarious. Like, wow, I mean, like premeditation. You went in there, you knew that this was going to be a public filing, so to circumvent the judge's order, you put it into a filing, and it got put out and disseminated into the public. That's what's bad here. That's the same shit they did in the Delphi case, as Lisa mentioned above. I mean, it's absolutely crazy. I mean, it's insane to me.
Did not match the rifle. Commentators described the ATF report as a bombshell that exonerated the defendant. Between March 31st and April 2nd, Mr. Ballard engaged in extrajudicial communications with multiple media entities. On March 31st, 2026, Mr. Ballard was quoted by TMZ stating, "Generally, when a bullet fragment analysis comes back as inconclusive, that means the fragment did not contain enough detail for the examiner to say one way or the other. There's just not enough there to determine whether the bullet was fired by a particular firearm. We have ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder, and we will present some of that evidence at the upcoming preliminary hearing, and we will present all that evidence at trial." Mr. Ballard further stated, "He is presumed innocent. The ultimate decision will be up to the jury. We believe we will be able to overcome his presumption of innocence."
That's why they're doing a case.
On March 31st and April 2nd, 2026, Mr. Ballard provided statements to USA Today and Politica Fact, strictly limiting his commentary to the mechanical and forensic definition of an inconclusive ballistics test, noting that ethical rules prohibit him from speaking publicly about forensic testing and the test results, but clarifying that inconclusive means only that the fragment did not contain enough detail for the examiner to determine whether the characteristics on the fragment were consistent with having been fired by a particular firearm. Having observed the demeanor and testimony of Mr. Ballard during the evidentiary hearing, the court finds that Mr. Ballard testified credibly regarding his subjective intent. The court finds that Mr. Ballard did not engage with the media out of a malicious desire to flout this court's authority or to intentionally taint the jury pool. Mr. Ballard testified that he believed his statements were necessary to respond to public reporting concerning the ATF report. In Utah, contempt proceedings are governed simultaneously by common law principles and the statutory framework outlined in Utah Code 78B-6-301. Section 78B-6-301 sub 5 expressly dictates that disobedience of any lawful judgment, order, or process of the court constitutes a contempt of the authority of the court. To hold a party in civil contempt for violating a court order, the moving party must prove three common law elements by clear and convincing evidence. 1, the person cited for contempt knew what was required by the order. 2, the person had the ability to comply with the order. And 3, the person intentionally failed or refused to do so. Utah law requires proof by clear and convincing evidence that the alleged contemptor knew of the order, possessed.
It's almost like he can't even read the words that are like, did he write them himself or did somebody else write these things? Like, I don't even know what word he just said.
The ability to comply and intentionally committed the acts constituting the violation. Von Hake remains controlling Utah precedent. Because the court concludes those elements are satisfied under existing Utah law, it is unnecessary to determine whether the objective good faith standard discussed in Taggart v. Lorenzen would independently alter Utah civil contempt jurisprudence. Even assuming Taggart provides persuasive guidance, the result would be the same because the challenge statements exceeded the objective limitations contained in Rule 3.6c. Contempt is categorized as either direct or indirect based on where the conduct occurred. Direct contempt occurs in the immediate presence of the court and may be punished summarily. Utah Code 78B-6-302 sub 1. Indirect or constructive contempt occurs outside the presence of the court and triggers robust due process protections. Because Mr. Ballard's extrajudicial statements occurred outside the immediate view and the presence of the court, this constitutes an allegation of indirect contempt. Due process for indirect civil contempt requires notice, an opportunity to be heard, and presentation of the charges via an affidavit or sworn statement detailing the facts constituting the contempt. The court must issue an order to show cause and hold an evidentiary hearing where the accused may present and answer and examine witnesses. Here, the court finds that all procedural due process requirements have been satisfied. defendant submitted an affidavit of counsel.
Yep.
The court
They
issued
had the
an
hearing.
order to show cause,
We watched
and
it.
the court convened a full evidentiary hearing on June 12th, 2026, at which the accused testified and presented argument. A critical distinction must be drawn between civil and criminal contempt, as the classification dictates the available sanctions. As the Utah Supreme Court articulated in Von Hake, the distinguishing factor is whether the sanction is conditional or fixed. A contempt order is criminal if the punishment is fixed, unconditional, and purely punitive, designed to vindicate the authority of the court. Conversely, a contempt order is civil if the sanction is remedial, designed to either compensate the aggrieved.
Come on, you guys. Do some commenting in the chat, okay? We've got, I know the judge he talks like a robot when he reads stuff like this. I assure you he's different, though, when he's not reading, okay? Like I said before, a long time ago, when this case first started, and they were doing these kind of hearings like this, he was doing another hearing, and I was just kind of going to go try to check out how to do it, how to get in on these hearings. So I went in there, and I joined the hearing, and I was sitting there, and then Judge Graff was talking, and he goes, "Hey, who's Gray Hughes?" I was like, I'm just somebody, I was just trying to see how it worked. Why are you asking me who the hell I am? I'm just sitting here. I just joined the meeting, Anyways, he kind of laughed too or whatever. It was just funny. And so I left. But it was weird. It's like, I don't know why he asked who I was. I mean, can't you just join in and you sit there on the side?
Party for injuries resulting from the noncompliance or to coerce further compliance through a conditional penalty. Because the defendant brought this motion seeking remedial sanctions to cure alleged prejudice to his fair trial rights, the court...
We know, K9, we know. I've already watched this whole damn thing, okay? Let people watch it for themselves in here. Thank you. I've already explained it. Thank you.
Evaluates this strictly as a civil contempt proceeding. This court's publicity order expressly incorporated Rule
And thanks for the 5 cents up there, K9.
3.6 of the Utah Rules of Professional Conduct. Rule 3.6 reflects the constitutional accommodations recognized in Gentile versus State Bar of Nevada, under which an attorney participating in pending litigation may be subject to narrowly tailored speech restrictions when necessary.
Well, what's weird is he's reading his own ruling. It should be kind of easy for him to, it's almost like he's reading it for the first time, like not knowing what a word is, etc. That's the part that's kind of strange.
Necessary to protect the integrity of an adjudicated proceeding. This rule therefore protects both the attorney's First Amendment interests and the criminal defendant's Sixth Amendment right to trial before an impartial jury. Neither constitutional interest is absolute. Each must be reconciled through a careful application of the rule's objective standards. Rule 3.6a sets forth a general prohibition. A lawyer shall not make an extrajudicial statement that they know or reasonably should know will be disseminated publicly and will have a substantial likelihood of materially prejudicing an adjudicative proceeding. Comment to Rule 3.6 explicitly enumerates subjects that are more likely than not to have a material prejudicial effect, particularly in a criminal proceeding. These prohibited subjects include the performance or results of any examination or test or the nature of physical evidence, any opinion as to the guilt or innocence of a defendant, the fact that the defendant has been charged, unless accompanied by a statement explaining that the charge is merely an accusation and the defendant is presumed innocent. However, the rule contains critical exceptions. Rule 3.6b permits the lawyer to state information contained in a public record without elaboration. Furthermore, Rule 3.6c provides a safe harbor or right of a reply. A lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyers.
Right. So the state, it was initiated. So the defense initiated the false information, and then the prosecution had to put out extra judiciary, whatever the hell the term you use, judicial comments to make sure that their client wasn't unduly prejudiced. You know, like they actually were trying to fix the record for the states. They're the client. You know, the people are the client of the prosecutors. And the defense intentionally tried to manipulate what people believe to be the truth about the case by hiding it inside of a document.
Client. Crucially, any response under 3.6c shall be limited.
Yeah, but you laughed at her comment.
To such information as is necessary to mitigate the recent adverse publicity. The Utah Supreme Court recently addressed the ethical boundaries of prosecutorial speech in a capital case in the matter of the discipline of David O. Levitt. In Levitt, a county attorney held a press conference announcing his decision to seek the death penalty and stated that the state's key witness was credible based on a lot of evidence that the jury will never hear, and that he possessed evidence strengthening his belief that the defendant committed the murders. The Utah Supreme Court held that a prosecutor's opinion of guilt is particularly likely to create prejudice, given that his or her words carry the authority of the government.
Yeah.
And are
You know, you can tell this guy wants to interject like every second, you know? He wants to come in and like say something. You know, he's like, because I agree with his, like, you can, where he thinks the judge is going, you know, you can see it because the judge keeps reading certain rulings, etc. Hey, it's Chris O'Connell.
especially persuasive in the public's eye. The court disciplined the prosecutor, recognizing while transparency is a
And by the way, thanks again to Chris O'Connell. I don't know if you guys saw last night, but her and Carl with a C got into a support challenge for the show, and you know, help make up for maybe one of the 2 or 3 days that, or maybe 2 of the days that we were way short of the goal. So thanks again to Chris O'Connell. Yeah, she was Corey Richard's attorney.
legitimate objective. Prosecutors possess a heightened ethical duty to ensure that justice is done, which includes respecting the constitutional rights of the accused, like the presumption of innocence. Civil contempt is an extraordinary remedy. Because contempt implicates both judicial authority and competing constitutional interests, the court defines its decision to narrow conduct presented by this record. This court possesses the inherent authority to regulate the conduct of attorneys appearing before it and the statutory authority to punish disobedience of its lawful order under Utah Code 78B-6-301. As noted by the Utah Supreme Court, courts must maintain and protect the integrity and dignity of the profession. A judge presiding over a high-profile capital case bears an affirmative constitutional duty under the 6th and 14th Amendments to take preventative measures against prejudicial pretrial publicity that could taint the jury pool. The enforcement of the September 16, 2025 publicity order is squarely within this court's jurisdiction and within the court's inherent and statutory authority. To hold a party in contempt, the order violated must be clear and unambiguous. The court finds that the publicity order was exceptionally clear. It did not rely on vague prohibitions. Instead, it explicitly incorporated the exact text and framework of Rule 3.6 of the Utah Rules of Professional Conduct. It directed the attorneys to abide strictly by its parameters.
Thank you,
The
Chris
incorporation of standard, universally understood rules of professional ethics renders this order unambiguous. The court finds that Deputy County Attorney Ballard had actual notice and knowledge of the order. The record reflects that Mr. Ballard signed a motion seeking to clarify the order in November 2025. He never contested his awareness of the order or his obligations under Rule 3.6 during the evidentiary hearing. The first element of civil contempt, knowledge of the order, is established beyond doubt. Defendant alleged Mr. Ballard's statements to the press between March 31st and April 2nd constitute multiple distinct violations of the publicity order. The court analyzes these statements by categorizing them in two distinct thematic areas. First, statements clarifying the ATF ballistics report, and second, statements regarding the overall strength of the state's case and presumption of innocence. Allegation 1, statements clarifying the ATF ballistics reports. The conduct. Mr. Ballard sent written emails to PoliticoFact and gave statements to USA Today and TMZ explaining the meaning of an inconclusive ballistics test. Specifically, he stated when the results of a bullet fragment analysis come back as inconclusive, that does not mean that the rifle did not fire the bullet. There just aren't enough marks on the fragment to make a conclusion one way or the other. Supporting evidence, quotes published in USA Today, PoliticoFact, and TMZ. Contrary evidence and defenses. The state argues these statements were expressly permitted by Rule 3.6c as necessary to protect the state from substantial undue prejudicial effect of recent publicity that the prosecution did not initiate. The defense initiated the media frenzy by stating in a public filing that the ATF was unable to identify the bullet to the rifle. The media twisted this phrase to mean the bullet did not match. Factual and credibility findings. The court finds that the defense's characterization in its March 27th motion to continue was technically accurate, but highly prone to misinterpretation.
Right. See, but they were smart about that. See, it was technically accurate, but the way they worded it could have been misinterpreted.
Framing the results as unable to identify, the defense neglected to include the ATF's concurrent finding that the bullet also could not be excluded.
Right, see, so they were technically correct by just putting in the part where unable to identify, but forgot to mention that it was not able to be excluded.
The media seized on this omission, generating headlines that materially...
No, the bullet match, Dragon, we don't, well, no, here's the thing. They weren't able to determine if it matched because it was fragmented so severely that the normal, like, striation comparison and stuff like that couldn't be. But the metal, it's likely going to be that the metal of the bullet is going to match the other bullets. You had the, the note on the bullet where Tyler Robinson said on the one that he fired, et cetera, et cetera, et cetera, et cetera, et cetera, et cetera, et cetera. I don't know. You must have missed all that. Have you not been following the case, Dragon?
He overstated the forensic conclusions, stating the bullet did not match the rifle. The court finds Mr. Ballard testified credibly that he viewed this media narrative as highly prejudicial to the state. Legal analysis. Rule 3.6c permits a lawyer to make a statement that a reasonable lawyer would believe is required to protect a client from substantial undue prejudicial effect of recent publicity not initiated by the lawyer. A false media narrative asserting that the murder weapon has been definitively forensically excluded constitutes substantial undue prejudice to the prosecution. Mr. Ballard's statements explaining the forensic mechanical definition of an inconclusive test were narrowly tailored to mitigate this specific prejudice. While
But we've covered it on here a million times. You must have got people got one of the free memberships. We've, Tyler Robinson, in my opinion, without a doubt whatsoever, 100%, I am 100% certain Tyler Robinson is the killer. There is no doubt. In fact, you're almost brain dead if you don't believe that. He 100% is a killer. There's no mystery to the case. The only part that's interesting for me is just seeing all the pieces of the puzzle put together so you can watch people's faces who thought he was innocent moronically this whole time. That's it. Okay? When this video was being, when this pool video was being streamed, the people commenting in there are so idiotic that it just wants, I almost want to like vomit of how stupid these people are, okay? It's crazy. I mean, it's just unbelievable. And trust me, it's not just, They just have a different opinion than you, Gray. No, it means you are a stupid person. If you believe Tyler Robinson didn't do it and he's some sort of a just kind of, shill by somebody, you're a moron, okay? That is just the truth. I don't know what else to tell you, okay? Now, people don't like it when I say that because they want to think, oh, I don't know, Gray. I have my doubts. If you have your doubts, you're dumb. That's it. I don't know what to tell you. All right, so here we go.
Amendment 5 generally prohibits discussing the results of the test. The safe harbor.
Out of all the years that I've covered true crime, this is the strongest case I've ever seen times 10. It is like ridiculous. And I've seen strong cases, The Koberger case. This blows that one out of the water. This thing is freaking incredible. Every single element that you could possibly imagine is there. His parents recognized him. He mentions the wording on the bullets. His DNA is on the gun that they found. The wording of the bullet that was fired on the shell is exactly what he said it was in a message he sent to Twiggs. He told Twiggs that he had the opportunity to shoot Charlie Kirk and he did it. It's just, and it just goes on and on and on. Like literally every single thing. His phone he is there in the area. His vehicle is in the area. He literally parked his vehicle right next to where the gun was found in the woods so he could try to retrieve it in the evening, and then eventually gave up. So his car is seen on camera doing that, and then he also texts how to get back home, searches on Google Maps to get back home at the exact same time too, and then he leaves and goes home. Okay, this is like ridiculous, this case here, how absolutely obvious it is. His parents recognized him on camera. They go, wow, that looks like our kid. Oh, by the way, the rifle that they found in the woods looks like exactly like the one that our grandfather gave him. It's crazy. Well, there's a death penalty in the case, so, he can't, they're not going to accept anything other than the death penalty, the prosecutors, and I agree with them.
Of Rule 3.6c authorizes otherwise restrictive responsive statements only to the extent reasonably necessary to mitigate.
And by the way, he hasn't pled yet. That's what's so crazy about all this. We're 9 months into this sucker, and he hasn't pled anything, and they haven't had the preliminary hearing yet. They didn't do a grand jury. Maybe they should have done that. Maybe they should have went grand jury and just boom. But they had a probable cause document. They have a preliminary hearing coming up right in the beginning of July, which we'll be covering here and watching it. No, they don't have a choice. It's not bad attorneys. They don't have an option. They have no win. They have no leverage. The defense, they're doing their job. That's why there have been, all this crap that we're doing. Even this hearing right here is because of their stall tactics. They know what they're doing. It works. Keep him out of prison as long as possible. Maybe we can get him on some technicality where death is taken off the table. Then the trial becomes sort of, have nothing to lose. He has stuff to lose now because death is still on the table. All right, but if you take death off the table, there's nothing to lose. Then you go to trial, he loses, and he gets life without parole anyways. Who cares? I don't know. It's I don't know. If he pleads guilty, he's going to get the death penalty. There isn't going to be like let's say right after the preliminary hearing, he pleads guilty, he's going to get the death penalty. Now, if he cuts a deal, the only deal that the prosecutors should take would be something where he has to sit on the witness stand for like 3 days of a hearing where he has to go through step by step exactly what he did on camera, explaining what he did in the different surveillance shots, etc., when he was there before, and he goes through the whole damn thing, and then you give him life without parole. Okay? That would be it. But then you have him on record describing everything that he's doing. Of course, the Candace Owens nut jobs will go, oh, look, they gave him a script to read. He didn't really do it. You guys are insane. All right.
The recent prejudicial publicity. Conclusions on Allegation 1. The court finds Mr. Ballard's statements clarifying that the ATF's inconclusive findings were protected by the safe harbor provision of URPC 3.
What kind of comment is that? Why not plead guilty without? There isn't, because there is a death penalty in this case. What are you talking about, Dragon? What are you saying? It doesn't even make sense. But why not plead guilty without the death penalty? Because there is a death penalty in this case. It's not taken off the table. It's right there.
6C. These statements do not constitute a violation of the publicity order. Contempt is not proven regarding these specific statements. Allegation 2, the statements opining on the strength of the evidence in guilt. The conduct. Beyond merely correcting the ballistics record, Mr. Ballard provided the following statement to TMZ. We have ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder, and we will present some of that evidence at the upcoming preliminary hearing.
Yeah.
And then we will present all of that evidence at the trial. He further stated, he is presumed innocent. The ultimate decision will be up to the jury. We believe we will be able to overcome his presumption of innocence.
So isn't everything you just heard there obvious, right? Right there, it was obvious, right? Like, yeah, that's why they're going to trial. You know, and then he even said, and he's presumed innocent until proven guilty. Right? That should be enough. That is such a minor, that's not even anything. It's just saying the truth. Now, if you said, I believe he's 100%, guilty, he's got this, and this, and ran through the litany of shit that I said, that would make a difference. But he didn't say that.
Supporting evidence. The published TMZ article dated March 31st, 2026. The state does not deny these statements were made. Contrary evidence and defenses. The state relies on State v. Wright, a Kansas case, arguing that a prosecutor's general statement that his job is to bring cases he believes he can prove beyond a reasonable doubt does not express an improper opinion on guilt. The state argues that merely expressing confidence that it has enough evidence to carry its burden tells the public nothing more than what the existence of the prosecution already proclaims. Factual and credibility findings. The court finds that Mr. Ballard subjectively believed he was operating within the bounds of Rule 3.6. However, the court finds that his subjective belief regarding these statements was objectively unreasonable. Legal analysis. Rule 3.6c strictly dictates that any responsive statement shall be limited to such information as is necessary to mitigate the recent adverse publicity. The adverse publicity here concerned one specific piece of physical evidence, a bullet fragment. The court does not conclude that Rule 3.6c prohibited all public response. To the contrary, Rule 3.6c expressly recognizes that in limited circumstances, counsel may respond to recent publicity not initiated by the lawyer or lawyer's client. The question is not, therefore, whether Mr. Ballard could respond, but whether a reasonable lawyer would have believed additional statements concerning the overall strength of the prosecution's evidence were necessary to mitigate the specific prejudice created by the inaccurate reporting concerning the ATF examination. The court applies an objective standard. The subjective good faith of counsel is relevant to credibility, but does not determine whether Rule 3.6c's limitation was satisfied. The state's reliance on State v. Wright is misplaced. Wright is distinguishable because it addressed statements made during voir dire rather than extrajudicial statements governed by Rule 3.6. As the Utah Supreme Court recently reiterated in Leavitt, when an elected prosecutor or their deputy makes public declarations regarding the strength of evidence or their belief in ultimate outcome of the trial, those words carry particular weight and authority of the government. Stating that the prosecution has ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder reasonably communicated to the public the prosecutor's assessment of the defendant's guilt, that the defendant was guilty. This directly violates comment 5, Roman numeral 4 of Rule 3.6, which prohibits expressing any opinion as to the guilt or innocence of a defendant. While Mr. Ballard offered a cursory nod to the presumption of innocence, he immediately undercut it by publicly broadcasting his belief that the state will overcome his presumption of innocence. These statements were not reasonably necessary under Rule 3.6c to mitigate the confusion surrounding the ATF report. Rather, those additional public statements possessed a substantial likelihood of materially prejudicing the proceedings by communicating the prosecutor's assessment of the defendant's guilt. Conclusion on allegation 2. The court finds that the statements to TMZ regarding ample evidence in overcoming the presumption of innocence violated Rule 3.6a and were not protected by Rule 3.6c safe harbor. Because Mr. Ballard knew of the order, possessed the ability to comply, and intentionally made the volitional statements in question, the elements of civil contempt are proven by clear and convincing evidence. The state and the UCAO possesses vital First Amendment interests in communicating with their constituents and defending the integrity of their investigation against false media narratives. Rule 3.6c accommodated that right by allowing Mr. Ballard to correct the inaccurate ballistics narrative. However, the defendant's Sixth Amendment right to a fair trial places a constitutional ceiling on prosecutorial speech. As the United States Court held in Gentile, the lawyer's right to free speech in a pending case is circumscribed because lawyer statements are likely to...
Hold on a second. We got people in the chat. Nut jobs that show up from Candace Owens' crew. Let's see. It says right here, on 9/11, Mike Mitchell, a former deputy, contacted Sheriff Brooksby. Mitchell explained that he had received a phone call from the father of Tyler Robinson. Mike Mitchell explained that Tyler Robinson confessed to his father that he was the shooter at Utah Valley University. Then 8:04, Sheriff Smith with the Utah County Sheriff's Office received a phone call at approximately 8:04 from Sheriff Brooksby with the Washington County Sheriff's Office. According to Sheriff Brooksby, he had received a phone call from a former deputy who had previously been employed with the Sheriff's Office. The former deputy, identified as Mike Mitchell, explained that he received a phone call from the father of Tyler Robinson. Mike Mitchell explained that Tyler Robinson confessed to his father that he was the shooter I think there's more in there. Yeah, there's a lot more. Shooter at Utah Valley University. Then 8:57, so he's still around at home, like he's not been arrested or anything yet. He's just told somebody. So about 53 minutes later, Tyler Robinson wrote on Discord, "Hey guys, I have bad news for all of you. It was me at UVU yesterday. I'm sorry for all this. I'm surrendering through a sheriff's friend in a few moments. Thanks for the good times and laughs. You've all been amazing. Thank you all for everything." Then about an hour and a half after that, Tyler Robinson arrived at Washington County Sheriff's Office accompanied by his parents at approximately 10:26. Then at 1 in the morning, FBI, so this is on the 12th now, FBI Special Agent Lang conducted an interview with the boyfriend of Tyler Robinson. At 1:58, Tyler Robinson was formally arrested by Utah County Sheriff while in custody in Washington County. Can I get a boom, you loser? Get out of here. Jesus, you guys are freaking stupid. All right, here we go.
To be received as especially authoritative. In capital cases where life is at stake, the court concludes that defendant's Sixth Amendment interests is predominant under these facts. The court's ruling is not based on disagreement with the prosecutor's viewpoint, nor on the mere fact that the challenge statements were made publicly. Rather, the court enforces a pre-existing publicity order that incorporated Rule 3.6, applied equally to all participating counsel, and governed attorney conduct in a pending capital prosecution. The contempt finding rests on the conclusion that the identified statements exceeded the objective limits of Rule 3.6c, not on the content of the state's position or the court's assessment of the merits of the prosecution. The remedial measures ordered are directed to preserving jury impartiality and future compliance with the court's order. Thus, the application of civil contempt sanctions here does not offend the First Amendment. For the reasons stated above, the court independently determines that the movement has proven by clear and convincing evidence that Deputy Utah County Attorney Christopher Ballard is in civil contempt of the September 16, 2025 and December 15, 2025 publicity orders. The court emphasizes this ruling does not address the merits of the criminal charges, the credibility of anticipated witnesses, or the ultimate guilt or innocence of defendant. Its sole purpose is enforcement of a narrowly tailored publicity order governing attorney conduct. A reasonable attorney invoking Rule 3.6c may respond only to the specific prejudice requiring correction. The prejudice identified here concerned the public misunderstanding of the ATF's inconclusive forensic finding. Once that misunderstanding had been fully addressed, further commentary concerning the overall strength of the prosecution's evidence did not materially assist in correcting specific misimpressions. Rather, those additional statements induced a separate subject,
You can't say
the prosecutor's assessment of the ultimate merits, which Rule 3.6 independently regulates. Conclusions of law. First, the pretrial and trial publicity order entered on September 16, 2025 and amended on December 15, 2025 was a valid, clear, and unambiguous lawful order of this court. Two, Deputy County Attorney Christopher Ballard had actual notice of the order, knowledge of its contents, and the unhindered ability to comply with its directives. Three, although Rule 3.6c permitted limited responsive statements explaining the ATF report, Mr. Ballard's additional statements concerning the strength of the state's evidence and anticipated ability to overcome the presumption of innocence exceeded the scope of that exception and violated the court's publicity order. Four, Mr. Ballard intentionally and volitionally made these extrajudicial statements, fulfilling the required elements of civil contempt pursuant to Utah Code 78B-6-301, sub 5, and Von Hake v. Thomas. Order and sanction. Having found Mr. Ballard in civil contempt, the court turns to the imposition of sanctions. The defendant argues that the appropriate sanction to remedy this prejudice is to strike the state's notice of intent to seek the death penalty. The court declines to adopt this requested remedy. As the state correctly argues in its objection, striking a capital enhancement or reducing the charge is not a remedial civil sanction. It is a fixed, absolute, and purely punitive sanction. Such an act would cross the threshold into criminal contempt.
So basically, he was found contempt on the extra part that he said about, we believe we have the evidence to prove him guilty. Well, of course you believe that. Why is that prejudicial in any way, shape, or form? Of course they believe that. They're the prosecutors.
Sanctions and would also risk an improper judicial intrusion into the executive branch's prosecutorial discretion. Civil contempt sanctions must be remedial, tailored to cure the prejudice caused by the violation, or designed to coerce future compliance. The court finds that striking the death penalty is grossly disproportionate to the misconduct and legally unavailable in this civil contempt framework. Before imposing sanctions, the court considered whether a mere finding of violations without remedial measures would adequately protect the integrity of future proceedings. The court concludes it would not. At the same time, the court rejects punitive sanctions that would intrude upon prosecutorial charging authority or materially alter the underlying criminal proceedings. The selected remedy addresses only the potential effects of the publicity on jury selection, and future compliance with the court's order. Accordingly, the court concludes that relief ordered constitutes the least intrusive means reasonably necessary to remedy the identified prejudice. However, the violation requires a meaningful remedy to compensate the aggrieved party and protect the integrity of the impending trial. The court draws guidance from the remedies deployed by the district court in Leavitt to cure jury pool taint. Therefore, it is hereby ordered. The defendant's motion for an order to show cause for contempt of court is granted insofar as the court finds Deputy County Attorney Christopher Ballard in civil contempt. Enlargement of jury veneer to directly remedy the potential taint introduced into the Utah County jury pool by Mr. Ballard's statements regarding the strength of the evidence. The court will consider expanded voir dire procedures, additional jury questionnaires, expanded jury summons, or other remedial measures as necessary after consultation with the parties.
What the hell is this?
Attorney's fees.
This was kind of
Because the civil contempt proceeding was necessitated by Mr. Ballard's violation, the court shall compensate the defendant for the reasonable attorney's fees and costs incurred in the filing, drafting, and litigating of the motion for order to show cause and the evidentiary hearing. Defense counsel is ordered to submit a detailed affidavit of costs and fees within 14 days of the order of this court. The state shall have 7 days thereafter to file any objections to the reasonableness of the requested fees. Future compliance. The court reaffirms the existing publicity order. Any future violation may result in additional contempt proceedings and sanctions authorized by the.
Yeah, I felt good that he didn't keep the death penalty. I mean, he didn't allow them to take the death penalty off, and he even said, almost like, that's ridiculous, you know. So that's good. Here's what I think is possible here, notwithstanding, you know, the reading problem. I think what he's doing here is he's sort of mitigating anything in the future. He's ruling that it was contempt, and then, but that his, you know, to, what's it called? You know, to make things right, he's not taking away the death penalty, but a smaller issue. You know, something like in the jury pool selection place. You see what I'm saying? Yeah. All right, here we go.
The law. Courts depend upon public confidence that criminal prosecutions will be decided.
I just think it's like for future where they could go, hey, he should have been brought up on contempt and blah, 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 blah. And he goes, oh, well, I did find that. I just didn't find the remedy to be as strong as you thought it was going to be. So that would be the issue in any sort of appeal.
Upon evidence presented in open court rather than public advocacy outside of it. This order should not.
Listen, hey, Penny. Let me just tell you something. Tyler Robinson is the killer, okay? There's no doubt about it. I'm sorry for your confusion.
Not be understood as discouraging legitimate public communication authorized by Rule 3.6. Rather, it reflects the court's obligation to enforce a previously entered order equally against all counsel and to preserve the fairness of the proceedings for both the defendant and the state. And this concludes the ruling of the court. Again, this will be uploaded to the docket before the end of the day.
And Penny, your perception of how what was written and the timing is absolutely incorrect. You're wrong. You're just technically incorrect. All right.
Counsel, let's move on.
Okay, they got some other stuff.
Turning to defendant's oppositions to EMC order for the preliminary hearing.
Yeah, exactly, Chris. They're going to keep looking.
The court will issue a written ruling by midweek.
They are going to try everything they can to get the death penalty taken off the table before the trial, because other than that, they know that their client's guilty and did it. So their fight here is just to save his life and get the death penalty off the table. They know that going to trial, he'll be found guilty, and then it comes down to, will the jury give him the death penalty? They probably don't want to do that. Nobody hid the truth about anything. Penny, listen, here's the thing. If you type any more of the conspiracy nonsense, I'm going to remove you from the show. And the reason is because you've effectively trolled the entire chat to the point where we're having a hard time, following along on the what we're listening to here, okay? You're putting out bullshit information just like all you nutjob Candace Owens followers do, okay? All right.
Next week, the court recognizes that both parties are actively preparing for the preliminary hearing scheduled to begin on July 6th. Given the time and attention required for that preparation, the court does not believe an oral ruling on the motion is necessary. The written ruling will be uploaded to the docket, and parties will receive notice once the court has issued its decision. Turning to the upcoming preliminary hearing, the court is mindful of the safety and well-being of all parties, counsel, witnesses, court staff, and members of the public who may be present. The court is also mindful of the duty to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. To serve those important interests, the court reminds all persons who will be in attendance that portable electronic devices will not be permitted in the courtroom or on the fourth floor. Portable electronic devices include any device that can record or transmit data, images, or sounds, or access the internet, including a pager, laptop, notebook, personal computer, handheld PC, PDA, audio or video recorder, wireless device, cellular telephone, electronic glasses, or an electronic calendar. This prohibition does not apply to legal counsel and support staff for the defense or the state in this matter, or the equipment permitted under any controlling electronic media coverage order. In addition, every person who will be in attendance will be afforded the dignity and respect due to them and pursuant to the September 24, 2025 Standing Decorum Order. All spectators shall be quiet, civil, and orderly. Spectators shall not engage in any distracting, disruptive, provocative, disrespectful, uncivil, or threatening behavior of any kind. Spectators shall not make any audible comments of any kind, shall not shake or nod their heads, and shall not otherwise make any gestures during the hearing. Spectators shall not wear or display pins, buttons, signs, clothing, or photographs expressing support for or against any person related to this case or the status of this case as a capital offense. Members of the media and public will be permitted in the courtroom subject to available seating. A limited number of seats will be reserved for each group and will be made available on a first-come, first-served basis. The court respectfully asks all persons...
I don't know of a case that warrants the death penalty more than this one. Just absolutely cold, methodically, plans out, goes to an event, hours away, drive, merely to kill somebody because he didn't agree with what they were saying. I mean, this is what the death penalty was made for, this kind of case.
Seeking admission to conduct themselves in an orderly and respectful manner while court staff and security personnel carry out their responsibilities, including security screening and the assignment of wristbands for entry into the hearing. Counsel, does either party require the benefit of the record?
Yes, Judge. Mr. Grunander for the state. A question. I know this order does not apply to legal counsel for the state or the defense or our staff that are there assisting us, but would the court permit counsel for the victim's representative to keep his phone on his person?
To defense, any input?
We have no objection to that, Your Honor.
All right. Mr. Grunander, based off no objection and finding it is in the interest of what is permissible, I will grant that request, and I appreciate that clarification.
Thank you. And then I have one other item that goes outside of this particular order, Judge, if you're ready to hear it.
Yes.
There may be some sensitive information that is presented during the preliminary hearing. And the state would like to be able to alert the court before that happens to allow for members of the victim's family to exit the courtroom prior to it being presented in the court. We anticipate turning the monitors away from the gallery, but there will be some audio that could be sensitive nonetheless. So we would like to inform the court that we would like to alert Your Honor before that happens to allow for them to exit the courtroom. And then once that is presented, allow for them to return to the courtroom. That would be the state's request.
Thank you, Mr. Grunander. To defense, did you want to respond?
It doesn't seem like a response is necessary from us, Your Honor. We think that's up to the court, how the court wants to handle that.
Thank you. Pursuant to Article 1, Section 28 of the Utah Constitution and subsequent Utah law, victims are entitled to be treated with dignity and respect. And I find that this request falls squarely within that, and I will grant that request.
I would say Tyler Robinson's demeanor, his past, prior, and stuff like that would probably make it tough for 12 people to, come up with the death penalty. Because he doesn't seem like you don't look at him and go, like his behavior prior and all that stuff, you don't go, oh, he's an evil person his whole life. There was this thing that he did, and that might be what the defense will try to mitigate him. Like, well, it was, his lover was transgender, and it was just so devastating to him that he just acted out in a way that, that's what they're going to try to say. Yeah.
Request. Counsel, just as soon as you can, as soon as it is upcoming, feel free to alert the court, and the court will take a brief recess to allow
What do you mean, Charlie Kirk,
victim representatives and to make that decision. And if they wish to leave the courtroom, they may do so.
Yeah, now you look
after
at
that evidence has been presented. Yeah. They will be allowed to return. So we'll take a recess after that sensitive material, as you've defined, is presented. And just if you could alert the court,
I don't
so a brief recess could be taken to allow them to come in to ensure that they are able to be fully present for as much as the preliminary hearing that they choose to participate in.
Right. Thank you, Judge.
All right, turning to defense, do you require the benefit of the record or wish to bring up any additional items?
Your Honor, Michael Burt for Mr. Robinson.
All right, Mr. Burt.
Judge,
have you guys not watched all the videos that I've made? I show exactly what Tyler Robinson did, how he walked there, went on the roof. I used animation, etc., to fill in the gaps. It's really clear, okay? So when you say, yeah, he went up on the roof, yeah, I know. I've covered it 100,000 times. I know exactly what he did. I don't need to throw every little element into it when I'm telling you that he deserves the death penalty.
Judge, at the last hearing, I indicated to the court that we would be seeking a ruling from the court prior to the hearing concerning...
It's anywhere near like killing the president. It's not even close. Okay? It's bad. It's, it's really bad, but it's nowhere near killing the president. Comparing the two... I don't think you can do that.
Some expert witnesses at the defense.
I think Robinson is he's autistic or something.
Said subpoenaed from out of state. And after discussions with the state, it appears that the state has no objection to the presentation of those witnesses. We have pared down the number of witnesses that will be called. And currently, there will just be 3 witnesses who will be called, 3 expert witnesses. The other witnesses we will be handling by way of a stipulation.
Thank you, Mr. Burtz. To the state, any input?
Yeah, he did, because he likes him.
That is accurate, Judge. We are working with defense.
It's not equivalent to shooting the president. That's like
counsel with respect to some stipulations. We have decided not to object to the presentation of these defense experts. With that said, during the hearing, there may be objections that are raised if the...
Oh, it's okay, Juju. Sorry about that.
Questioning or answers seeking to be addressed goes outside the scope of the preliminary hearing or borders on a 702 hearing. So we want to preserve those objections.
I don't think he's dumb.
All right. Thank you, Mr. Grunander.
Tyler Robinson, I don't think is dumb. I think he's, I think he's articulate. I think if you want to call him dumb and he's got a low IQ, then you have a good chance of getting him off on just being mentally challenged. I mean, I don't think that at all. And when you see his writing, he doesn't seem stupid.
Ms. Nestor, anything further? Or Mr. Burt? And again, I appreciate all parties bringing these issues up now just to remove any misunderstandings.
Nothing further.
See, here's the thing: is if you try to actually speak like reality, like when you see Tyler Robinson, he got a scholarship. He's not stupid at all. He's just one of those people that is like a drone in life. He's not stupid. Okay, I mean, it's like he got a scholarship. He writes well. He seems like he's, knowledgeable about stuff. And that doesn't see, but whenever you do that kind of stuff and you say that, people go, "Gosh, great." You just want everybody to say the worst things about somebody because it makes it more fun or something. I'm just telling you the reality. He's not an idiot, and I don't want him to be an idiot for this trial because that makes the premeditation angle even more stronger. Like if you start going into the trial and you go, yeah, well, look at this. He got a scholarship here. He's not dumb. He knows exactly what he's doing. And look what he planned out. He did this, 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 and this, and this. If you start going, well, he's got a low IQ. He's a ditz. He can't even tie his shoe half the time. Then all of a sudden it's like, okay, well, maybe he needs to be in a mental institution where he puts together blocks and circles or squares or whatever the hell it is.
Further for me, Your Honor.
The defense has nothing else, Your Honor. Thank you.
All right. Lastly, the court wishes to inform the parties that as it relates to exhibits being presented in regards to whether it's published or not in open court, or if copies of the exhibits are given to the public or news media, I will take that on a issue by issue basis. So per exhibit, all parties will be entitled to object, not object, stipulate. So we have a clear record and the court doesn't make a blanket ruling as each individual exhibit is its own exhibit. And the court wants to apply the appropriate analysis to each exhibit presented in court. As the court does not know and cannot anticipate what exhibits will be presented, even though there has been indication what will be presented, it doesn't become relevant until it's actually moved into evidence. And so that's why the court is not issuing a blanket ruling, wants to see where it's coming in, all the factors that govern whether an exhibit should or should not be admitted and should or should not be published to the court, to the parties, or... Yeah,
I think it would get to, like Jodi Arias. What a perfect case for the death penalty that was, right? But each time in Arizona, you get 2 bites at the apple for the penalty phase, which is crazy. So both times around, I think it was like 11-1 for death and 1 holdout, so she didn't get the death penalty. So there's always that chance, but 11-1 means that, people are more aligned with the death penalty. It's just that there's one idiot out there, that never should have been on the jury in the first place.
To the public. And so I just wanted to give that clarification because perhaps in the back of your mind, you were wondering. All right, counsel, I also wish to remind you the purpose of the preliminary hearing and the stand.
When have you seen him where you observe lost? I'm stating what I've observed. He seems lost. Where? What video did you watch where he seems lost?
Standard, and I offer that simply as a reminder as you're presenting your evidence. That is a standard that the court is holding to, and just wanted to provide that for guidance to all parties. Unless there is anything else, we will reconvene on July 6th, 2026 at 9 a.m. for the preliminary hearing in this matter.
Wait, what date did he say? I thought it was the 6th.
And the standard, and I offer that simply as a reminder as you're presenting your evidence, that is a standard that the court is holding to. And just wanted to provide that for guidance to all parties. Unless there is anything else, we will reconvene on July 6th, 2026.
Oh, 6, okay.
26.
Oh, the 2020.
At 9 a.m.
That got me confused when he said 2026 right after that.
a.m. for the preliminary hearing in this matter.
July 6th,
Court is
2026.
Thank you, Your Honor.
All right. Yeah, so when you're saying he looks lost, are you talking about in the hearings? I think what he looks like to me is resigned. Like he just kind of knows he doesn't really have a shot, so he just sits around and, kind of just stares and like whatever, Doesn't have anything to say, nothing to add. Yeah. Let's see. But, whatever he is, right? I don't think like here's the thing. I don't think when Tyler Robinson goes to a party, people stay at the party because he was there. All right. They don't go, well, Tyler's here. Shit, man. Woo. It's going to be good times. Yeah, no. Let me see. So let's go through this really quick here. So what we were talking about a minute ago, that person in the chat was like, oh, they're Miranda rights. Oh. And nobody asked Tyler. No, Tyler never responded to anybody. So here's how it goes. On 9/11 in the evening, Tyler Robinson arrived at the Washington County Sheriff's Office. Remember, he turned himself in to some guy that used to work there. And then he got a hold of, let's see, what was it? Brooksby, that other guy, and brought Tyler Robinson in. So then he arrives there at 1:26. So that's why he had time at 8:57 to be typing to friends saying, hey, sorry, you guys. And then at 1 a.m. on the 12th, FBI Special Agent Lang conducted an interview with the boyfriend. All right. So that was at 1 a.m. And they were trying to probably get information from him so that they could interview Tyler Robinson later with that information. So then at 1:58 a.m., Tyler Robinson was formally arrested by the Utah County Sheriff while in custody in Washington County. So they had detained him in Washington County, but then transferred to Utah County custody, and they arrested him formally at 1:58. And then at 7:58, he was booked by the Utah County Administrative Process. So he was, after being driven all the way back, and that's about how long it takes to get there, from Washington County all the way to Utah County, he was booked into Utah County. Then at 8:14, he's still, he's in custody. And then at 6:25 p.m. that day, so wow, like 10 hours later, Utah County, they ask him questions. So he was, so Tyler, before we begin, I'm just going to read you your rights. Okay, you have the right to remain silent. Anything you say, they go through the whole Miranda rights. Then at 6:26, I would like to speak with my legal counsel. I'm hoping for a fellow in Utah named Doug Terry. Okay. Told he's a great guy, etc., etc. But he says, but until I've had the opportunity to speak with someone, I would like to remain silent. And that's it, man. That is so clear and obvious, simple. Okay? He didn't reveal any. He wasn't supposed to do Miranda rights when he spoke to the Mike Mitchell guy. He was just somebody the family turned him into. Simple stuff. Oh, in the hearings? Okay. Hey, thanks, Paul Ayers. Look at he's trying for a wave, you guys. Let's see if we can get a small mini wave right before the end of this show, just so I could pretend it was worth the hour and 20 minutes. Let's see. Yes, the hearing. Okay. But see that right there? That's why it's valuable to have these timelines. This is the actual timeline put together from the documents that are out there. All right, there isn't some other crazy, these people that follow Candace Owens are absolutely nutbags, or a nut job dirtbags. Hey, nutbags, I like that one. Nutbags. I mean, they're crazy people. It's absolutely insane. They forgo logic, reason, and common sense to try to free a killer. I mean, it's bizarre. Anyways, I hope you found it interesting. I guess in the, to summarize, there was like two elements of contempt. One was the part about where he was correcting the record that was falsely put out. Or, well, it wasn't. It was factually accurate what the defense put out, but left out the contradictory portion, which allowed the media to run wild with it. So the prosecutor put out information stating that it doesn't mean the bullet wasn't used. They just weren't able to forensically tie it because of the severe fragmentation. And the judge ruled that that was okay. However, he ruled that he went a bridge too far when he stated that we believe we have enough information to overcome the burden of proof in this case, blah, 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 blah. Yet he's still, he's innocent until proven guilty, but we think we can, and somehow that was too much. And I think that wasn't too much, but the judge, just to eliminate this and gave him contempt anyways, was just probably to make it safe in the future for any attempts at trying to use that as a grounds for an appeal or something like that. So that's off the table now. It's like, yeah. And then maybe some other judge would have to say, well, was it fair that you only just gave him some relief on the jury selection? Maybe you're giving him 3 extra strikes or whatever. Who the hell knows what that's going to be. Hey, thanks, Chris O'Connell. All right. Anyways, I think that's going to do it. All right. So thank you all for being here. Don't forget to watch the trial here, because we'll actually be able to cover it better than everybody else, since I know the case inside and out and I've been there. I have all 360-degree videos of every single location, basically, that they'll be talking about. And I think you'll find it interesting to be able to sort of see. It'll be a much more rich experience than staring at some defense attorney in the corner blabbing about what the hell they're looking at. It just doesn't, we know what we're talking about here. All right. Well, thanks, everybody. Really appreciate it. We'll see you guys later. And if you could hit that like button on the way out the door, that would be awesome. And we'll see you guys maybe tonight. I think on tonight's show we might do a call-in regarding some of that new Nancy Guthrie stuff. I think people, it'd be cool to just listen to what people's thoughts are on that. All right? So see you guys later. Thanks for being here. And as I always say, until next time, be safe out there. Hey, that's Jody Ryan's case.
The truth is, they're as dumb as they come.
It's a house!
Evil can never be dead enough. And some of you make shit up.
Candace Owens followers.